Good afternoon, everyone. I hope all of you are doing well. Uh, just be calm, be patient, and this time is going to pass. Till that time, dedicate as much time as possible to studies, read as much as possible, and just stay safe. Stay inside your homes, and most probably everything is going to be normal again very soon. Okay, so today I'll be dealing with second appeal. The material regarding appeal in general and first appeal has already been uploaded by me on the official website of Lucknow University. So you can just go and download that material from there and read it, and then you can come to this video. Okay, so we'll start with our first slide, and it talks about provisions relating to second appeal and what are the essentials to section 100, which deals specifically with second appeal. So first of all, we all know that appeal is not a natural or inherent right, it is a statutory right. It means that unless and until a statute does not expressly confers it, a person cannot appeal it, and the statute which confers such right also lays down the limitations within which the right can be exercised. Okay, so as far as second appeal is concerned, it lies in High Court, and the relevant provisions are Section 100 to 103, Section 107 to 108, and Order 42 of Civil Procedure Code. Now, when you're going to read Section 100, you will find out that there are certain things which you need to learn and you need to remember. That second appeal, first of all, lies in High Court, and this appeal lies against every decree that has been passed by any court subordinate to the High Court. And this appeal is not going to lie if there is no involvement of substantial question of law. It may also lie against an appellate decree which has been passed ex parte. Now, the memorandum of appeal has to precisely state what is substantial question of law. In this regard, you can also refer Order 42, Rule 2, and Order 41, Rule 11. So, these rules basically tell you that the first appellate court can also mention the substantial question of law in the order of judgment that it passes in the appellate jurisdiction. Next is that even though the parties specifically mention the substantial question of law, there is requirement under Section 100 that High Court also frames it. So High Court is also going to formulate the substantial question of law. It is generally at the stage of admission of the second appeal. Now, next is that the opposite party, that is the respondent, can always argue that there is no such question involved in this particular case. Now, very proviso to Section 100 is very important because it says that High Court can also hear appeal on any other substantial question of law which has not been formulated by it, provided it is involved in the case. Okay, so we have seen one thing that I've mentioned substantial question of law a lot of times here, and when you're going to read Section 100, you will find that you'll find the mention of substantial question of law very much, and in second appeal and appeal to Supreme Court, it is very important. Okay, so what is substantial question of law? First thing, substantial question of law has nowhere been defined in CPC or anywhere else, but you find the mention of substantial question of law in Constitution as well. So let's just see what substantial is. So, requirement of substantial question of law, you can read Sir Chunilal Mehta and Sons Limited versus the Century Spinning and Manufacturing Company Limited case. In this case, Supreme Court has laid down as to what substantial question of law is. So, I have just broken down how can you identify or what is the procedure that is to be followed by High Court in second appeal, and it is that first of all, the High Court is going to see whether the question involved in the appeal is of general public importance or whether the question is such which directly and substantially affects the rights of the parties. Now, you need to understand that as far as Section 100 is concerned, we focus more on whether the question directly and substantially affects the rights of the parties or not. We lay more emphasis on the rights of the parties that are involved in a particular case. Okay, next we see, after determining if there is involvement of either of these questions, we see whether that particular question is open open question or not. Open question का मतलब क्या है? The open question means that it has not been finally settled by the highest court. Highest court here would be Supreme Court, Privy Council or Federal Court. Now if the question has been settled by the highest court, or the general principles which are applied for determining this particular question, they all are well settled, in that case the appeal is going to be rejected, because the question is already closed and it has been closed by the highest court, so no second appeal on the same question is going to lie. Now, next step would be, if the question has not been settled, then what will happen? The High Court is going to see whether that question involves calls for a discussion or not, whether there is a room for alternate view on that particular question or not, and whether there is a need to decide such question or not. If these things are seen, after that the court can proceed determining such question. Now, if High Court at the stage of admission holds that the question has been properly decided by the first appellate court, then the second appeal will be rejected. Now, I've already mentioned that for the purposes of section 100, we will see that the question may be confined to the parties only and not of general public importance. Now, we'll study few examples. Now, the first example of substantial question of law lies in the case of Sau Hela Balasaheb Kadam versus Balasaheb Hindurao Kadam. It is a 2015 recent case. So in this case, the question was regarding the maintenance that was claimed by the second wife. Now this maintenance was claimed, but there was suppression of fact of the existence of first wife also, and the fact that the second wife deserted after the fact that cruelty was committed on her. Now whether in these circumstances the maintenance is still possible or not, maintenance is still maintainable or not, will be a substantial question of law. Other things are misconstruction of evidence or document, if there is any question regarding admissibility of evidence, or if the questions are if there has been misreading of evidence, or if the court has wrongfully placed onus of proof on a wrong party, or if there has been error in the interpretation or construction of material documents like title deeds or etc. In that case, the High Court can entertain such questions, as it will fall under substantial question of law. Good. I have mentioned just few general points regarding second appeal. Now first is that there is a difference between substantial question of law and question of law, and this was pointed out by the Supreme Court in the case of P. Chandrasekharan versus S. Kanakarajan. It is a 2007 case. Now what is the difference? The difference lies in the prefix substantial, which has been used in section 100. Now the substantial signifies that any question of law which affects the final decision in a case will be a substantial question of law. So basically, if any question of law has an impact or effect, or it directly affects the decision in a particular case, or it directly affects the rights of the parties in a case, then it will be a substantial question of law. There is no straitjacket formula to determine a substantial question of law, and it is going to depend upon the facts of the case. Now, another important point that you need to understand is, and which you'll come to know also when you're going to read the material, is that High Court cannot entertain questions of fact in second appeal. If the finding of the lower courts are concurrent and if the findings are wrong, in that case the High Court cannot interfere in all the circumstances, but in certain circumstances it can interfere. And what are those circumstances? If the findings of the lower court has been are based on misreading of evidence or are perverse, in that case the High Court can definitely interfere on the finding of fact also that has been given by the lower court. Now, High Court cannot reverse a lower court's judgment without framing a substantial question of law. It has to comply with requirements of section 100. Now, if the appeal has been rejected by the High Court, then there is no requirement of framing of substantial question of law. Now, with regard to interference by High Court on the finding of fact by lower court, you need to read these two cases, Rajasthan SRTC and Iswari versus Parvati. These both are recent cases, and they both have laid down that High Court in certain circumstances can also entertain second appeal on pure questions of fact, provided the factual findings are found to be perverse, or the appellate court or the first appellate court's finding are not supported by evidence. In that case, High Court, in exercise of its power in second appeal, can also entertain questions on questions of fact also. Okay, so limitations with regard to second appeal are mentioned under section 101 and 102. 101 basically says that no second appeal is going to lie on any other ground than the grounds that are mentioned under section 100, and section 100 basically emphasizes on substantial question of law, involvement of substantial question of law. When you're going to look into section 102, it says that if subject matter is for recovery of money and the amount does not exceed 25,000 rupees, in that case the second appeal is not going to lie. Now section 100A is important as it talks about letter patents appeal, and it says that if a second appeal if in second appeal a decree has been passed by a single judge of High Court, then no further appeal is going to lie against such appellate decree. Now, there is a difference between second appeal and revision. Revision has been provided under section 115. So what is the similarity between these two provisions, 100 and 115? Both revision and second appeal lies in High Court, first thing. And difference is that revision basically lies on jurisdictional errors. Jurisdictional errors basically imply that where the subordinate court has exceeded the jurisdiction or has exercised jurisdiction when it did not have so. So you can also at this point refer to the concept of inherent lack of jurisdiction and this thing, irregular exercise of jurisdiction, then you'll understand it better. Now in second appeal, in some cases and under certain circumstances, questions of fact can also be entertained, but that is not the case under revision. And under revision, the High Court can always decline to entertain the application, can always decline to look into the records of the subordinate court if it is satisfied that the justice has been done or substantial justice has been done. But if a second appeal is filed and there is involvement of substantial question of law, that the High Court has no option but to entertain it. Okay, now next is error in formulation of substantial question of law. As we have discussed before, that substantial question of law is basically formulated by the High Court at the stage of admission of second appeal. Now in this Asst Sheikh versus Bani Prasanna Kundu, what happened was the judgment of High Court was challenged before Supreme Court on the grounds that the High Court did not formulate the substantial question of law at the admission stage. Rather, it formulated the question after the conclusion of the arguments of the parties. So in this case, Supreme Court held that this particular act of High Court does not preclude the parties from being heard, because of the error of court, the litigants cannot be penalized. And it was also held that substantial question of law can be framed at a later stage also, provided the opposite party is given a notice and an opportunity to meet the point for to meet out the points of determination. Then High Court's decision can be set aside for non-compliance with Section 100 only on the grounds that it has caused certain prejudice to the appellants by not framing the question. Okay, so that's it. Thank you so much for listening to me. I hope you people understood the concept of second appeal and what a substantial question of law is. Thank you so much.